Well, welcome everybody to a Thursday night that I hope in the next little bit of time to talk to you very specifically about things that I've seen as I've helped physicians plan for their retirement. At our office, we actually do quite a bit of this, and we notice that there are common themes throughout, and I'll talk about those tonight. In fact, quite honestly, what we did with this presentation was really kind of focus it on things that maybe that I would hope I've guessed correctly and are important to you. So we're going to talk about planning for the second half of life. And I think that's really important. In fact, I love the languaging of the second half of life. You know, it lets us know how long of a time it is, and it lets us know that, you know, there's a lot of time and things can change in it. So as an elder law attorney, what I do on a daily basis essentially is help people answer three questions. The first question is, if you die, where does your stuff go? Who gets it? How do we get it to those people in the simplest, most tax advantage manner possible? And one of the things that's really important with that is that we need to make sure that whoever you're working with understands the consequences of income taxes and not just transfer taxes such as inheritance taxes and federal estate taxes. And we're going to talk about that tonight. The second question is, what happens if you don't die and you get sick? How do we make sure that you get access to good care? And how do we make sure that we are able to pay for that care and access any benefits, or ahead of time that we've bought insurance or a creative financial solution to help protect against that risk? And so for many in here, our goal would not be to get you on Medicaid. Our goal in the planning process would be to say, is there items that we can help you look at that can help protect, insurances that can help protect? And for many people, all they know about is traditional long-term care insurance. And there's a law that's called the Pension Protection Act. So if you have a lot of qualified money, IRAs, 401ks, that can work quite well for you to leverage that. And the last question is, what happens if you don't just get sick, but you get an Alzheimer's or a dementia? And I don't have to tell you guys about that journey. You certainly get it. But one of the things that we try to do with our families that we help is to prepare them for decisions that can be made so that hopefully they find themselves in crisis situations less often. So they as a family work through those things. I actually just lost my father-in-law to a 14-year battle with dementia, and have certainly professionally witnessed what a family goes through, but also personally. So very exciting stuff, right? Glad you got on here at 7 o'clock on a Thursday night. So I am a certified elder law attorney. I'm actually very close to also getting my LLM. I spend my days either in our Williamsport office or our state college office. I actually live outside of Jersey Shore, and I end up going to both offices. We only focus on estate and elder law planning, and one of our things that we do under there is what we call wealth protection planning. And wealth protection planning is about, you know, adding in the income tax consequences for those who might be slightly more affluent, may have saved more money, and now are hitting retirement and the thought of passing it down to the next generation, and we need to deal with what's the best manner to do that. I'm definitely an attorney who really loves to educate. I think my job is to tell people what their options are, educate them about that, and then help them pick whatever aligns with their goals. So at our office, we have available for anybody that wants them all of the books that you see here. One, very close to the seminar, what you really need to know for planning for the second half of life. The second, don't write a blank check to a nursing home. And then we have a series of books that we've done about Alzheimer's and dementia, both from the perspective of living with Alzheimer's and from the person that's caring for somebody who has Alzheimer's or dementia. We actually see quite a bit of that in our practice. And because I'm really an older attorney. I've been doing this for quite a while. Many of my clients come back in who maybe saw me 10 or 15 years ago, and they did an estate plan, and now they come in for a review. And one of the things that I've learned is often the reason that they come in for a review is that they recently got a diagnosis, or they're worried about a diagnosis. And so, it's interesting. 20 years ago, 25 years ago, when I started my career, people didn't talk about Alzheimer's or dementia. It was kind of taboo. And often they wouldn't get to me until they were right in a crisis. They were, the caregiver, a spouse, was sick herself from caring for her loved one. And today we see that very differently. We see people coming to us earlier in that disease journey, which is really great. So I am an attorney, so of course we have to talk about documents. Now, I will tell you that this is not going to, this seminar tonight is not going to focus just on these documents, but honestly, I had Kyle just add these in because I felt like I would be remiss not to at least talk about them. We're going to focus more on retirement assets such as IRAs, 401ks, where really many times the bulk of your money is, and we need to decide what to do with that. And doing nothing's not a good choice. So powers of attorneys, they are the simplest documents. They simply say, if I can't make my own decision, this is who I want to make it. Really powerful. You guys understand the value of that. There's 4 kids standing around. Who gets to make the decision? Who should you be talking to? So it's really great if people do this. Powers of attorneys in Pennsylvania are very difficult because I can remember when I was a kid and I would go to my dad's law firm and he would send me down to Plankenhorns. And Plankenhorns, I would get this sheet of paper, and in one sheet, although it was legal size, one sheet, it would say, I give this person my power of attorney, which means they get to make all of my decisions if I'm not able to. Today, each of these documents, a financial power of attorney, a healthcare, mental health, and living wills, they all are over 10 pages each. And that's because the legislature said, if you want to give somebody power, it must say it in the document. So as an example, if I want somebody to be able to enter my safety deposit box, it has to say that in my financial power of attorney. And so we've went from 1 page to like 50 pages to actually accomplish the same goal. I can't underscore enough how important these documents are. Anybody over the age of 18 needs to have them. I actually have 2 kids over the age of 18. I have a 24-year-old and an 18-year-old, and on their 18th birthday, they got powers of attorneys. They were thrilled, just so you know. They were so glad that their mom was an elder law attorney on their birthdays. But when I talk to my clients, I often say, if you're in a car accident, who is it that you want to pay your bills, and who do you want to talk to your doctor? And for me, it is that simple. Who's going to rush to the scene? Who's going to be there? Unfortunately, in everyday practice, kind of what I go through is that many people, appoint the child that they think expects it. They appoint their oldest child or the child that lives with them. I really try to combat that and say you need to pick the person who is going to make the best decision and be able to be in there and do that. So we have financial powers of attorneys. If you have financial powers of attorneys, please know that the law drastically changed in 2015. So if they're older than 2015, you do need to get them updated. Healthcare powers of attorneys have not changed for a very long time. The biggest thing that I go over with clients is to make sure that they say what the person wants them to. And I'm sure all of you understand how useless those documents are in an actual situation. With our clients, we also often say to people, it's not just the documents, it's having a conversation with your loved ones about what types of decisions you would want them to make. So the documents are important because they give us legal authority, but they're not overly helpful in the situation to decide when is the exact time to pull the plug or what do you want to do. And again, I'm not going to talk about that a lot tonight, but because I imagine that many of you live and breathe this and are on the opposite end of what I end up doing. Um, Finally, there's mental health powers of attorneys. They're not well known in our state. Some institutions really require them and some don't. They came into law in 2013, and it's a document very specific to if I'm getting any type of mental health treatment. So at our office, we definitely do mental health powers of attorneys and really suggest particularly anybody who has a diagnosis that is a mental health diagnosis or have a diagnosis of any type of a dementia that they should do mental health powers of attorneys. Then we have wills. Wills are just documents that say who get my stuff. We often in Pennsylvania don't want to use wills. We want to avoid probate. And you can do that by using a trust. You also can do that by naming beneficiaries on your documents, and we're going to talk about that a lot tonight. Interestingly, wills are documents that haven't changed very much at all. If you have an old will, if it still says what you want it to say, it probably doesn't need updated. The law has not changed the entire time that I've been an attorney. So, you know, it's kind of an old English common law holdover. Pennsylvania has the form that they want, and they're not straying from it at all. So, trusts are things that we utilize to make sure that we meet some sort of a goal. We're going to talk a little bit more about that. So, we talked about a power of attorney. It's just a written document that says that I want this person or these people to be able to make decisions on my behalf, financial, healthcare, mental health. The living will, again, I already mentioned this, but just to go over it again, that's a document that says it's okay to not continue artificial life-sustaining support. And that's the document that, although in Pennsylvania is technically necessary, doesn't really help people exactly make that decision. And so that's where we really suggest to people to have conversations with their family members. As an aside, one of the best sources of information from my perspective is a nonprofit out of Boston called the Conversation Project. And you can download their guides for free, and it helps family have these conversations. And please know, I've worked quite a bit with Dr. Nesbitt. Death and dying is something that I find intriguing in our societal response. So I think the Conversation Project is probably one of the best written guides to help families with that, and something that can then supplement that living will. A will, as I talked about, this says where your stuff goes. For most of you on this Zoom tonight, we would not overly want to use a will. In fact, we would want to avoid probate so that we get some privacy and that we also avoid probate fees. But the other thing that we have to know about wills is if you still have any children under the age of 18, it is the place where we appoint a testamentary guardian. So who gets the kids when we pass away? Honestly, one of the most difficult questions for me, I think I changed my will like 4 times when my kids were little. I was driving my husband a bit crazy, but an important question. So for many people, we'd want to think about, is a trust helpful for you? It's only helpful if it accomplishes a goal. And we'll talk about those goals. You know, at my office, we don't say everybody needs a trust. We want to think about what your personal goals are, and we'll talk about some goals that trusts accomplish. But when we think about, you know, using the word trust, it's not very descriptive. It doesn't tell us much more than, you know, if I tell you I drive a car, don't know if I drive a Jeep or a Suburban or, you know, what it is. When we think about the type of trust, we can think about that being the vehicle, adding assets to it, you know, putting your home in a trust, putting assets in it. That's like putting the gasoline in the car. And you always have to have a driver of that car or trust, and that's the trustee. That's the decision makers. For many of you, if you set up a trust during your life, you would be the driver. You would be that trustee, and you would make all the decisions upon your death. And then you would decide who after you got to make those decisions. So what are some reasons why we would use a trust? Well, first, I already talked about, it's to avoid probate. Now, I have to tell you, I don't often do a trust just to avoid probate, unless there's issues of privacy. But there are probate fees in Pennsylvania, but the probate process is not horrible in North Central Pennsylvania. I have to tell you, it's case by case. During COVID, some counties were a lot better than other counties. In Center County, where my state college office is, we never missed a beat. We continued to probate estates and move forward through the entire time. In Lycoming County, we were completely shut down for 8 weeks, which was difficult. So in those situations when people had stuff going through their will and I had to probate their estate, which meant I took that will to the court and had this executor signed in, if I couldn't do that, I couldn't get access to their money. So it was a difficult time. We sometimes use trusts for long-term care protection. So I put my house or my farm in a trust, and then it does not need to be consumed for my long-term care costs. Now, again, for some of you on here, I'm going to guess that, that could be something that you want to do. It may also be that you should think broader about, different types of financial products, whether it's life insurance with a long-term care rider, whether it's an annuity that doubles as long-term care insurance, whether it's traditional long-term care insurance. There are things that you should think about as we move through this. For some people, their financial advisor is not able to help with that conversation because that's not really their specialty. Your financial advisor may be really good at making your money grow, but what we need to do is protect it. And so there's some really neat products out there that can really leverage your money. Controlled gifting. So it means exactly what it says. For some people, they want to, a little bit rule from the grave. They want to control the manner in which people get things. Do they have to use it for education? So a lot of times when I set up grandchildren trusts, it goes to the grandchildren, but they have to use it for education, and either they don't get it or they get it a lot later if they don't use it for education. In my own estate, if I were to pass away, my children would receive the first set. They would receive the money in 3 increments. The first step at 27, this next half, next 1/3, half of what's left at 30, and then at 33, they would receive the rest. And that's a controlled gifting. For many of us, we have to think about, unfortunately, if you pass away, or whoever's going to inherit it used to dealing with that amount of money. So a statistic that has always stayed with me and hasn't changed in 25 years is that anybody who wins the lottery, 85% of people who win the lottery financially are worse off 2 years later. So please know, every family is different. But in some families, when you pass away, although they're very sad about you passing away, it's like they financially hit the lottery and they're not exactly sure what to do with it or how to handle it. And it's in situations like that that we want to do some controlled giving. Now, that's a very general statement. Of course, everything that I'm saying tonight, you would have to individually talk to an attorney about your individual situation and your individual kids or other beneficiaries. But it's a real phenomenon. Trust me, I sit across the table from your kids when you pass away. I've had kids who've bought trucks prior to even coming to me. I've also worked with some amazing, wonderful individuals. And so it's, all for what you feel about. And for some of you listening to me, you may think, I don't care, I'm dead. And that's an okay way to feel. It's all about how you feel and what's important to you. A next example of why we would want to use a trust, and this is, to be honest with you, probably one of the most prevalent. People tell me all the time that they have wonderful kids. It's their in-laws that are the problem. And, you know, what we want to do is to make sure that if you give an inheritance to your child and that child ends up getting divorced, that inheritance isn't part of what we call equitable distribution in a divorce. And one of the only ways to achieve that is using a trust. And so, you know, there are realities to that. So some people say, you know, I want to give this to my kid. My kid can be their own trustee. They can do whatever they want to with the money. But if for some reason their divorce, there's a divorce, I want to make sure that this money, whatever is left, stays with my child. And that is something that a lot of people do. Statistically, it is something that we have to think about. And so unfortunately, that's the world that we live in. We also worry about reducing exposure to federal estate taxes. Now, federal estate taxes are about 40%, but the exclusion is over $11 million right now. So that means that you can die with over $11 million and not have to pay federal estate tax. For many of us, that means that we don't have to worry about it. The problem with that is right now, that law is set to sunset. And what that means is that if the government doesn't take any action, the $11 million will go away and it will sunset back to the $5 million it used to be plus an inflation index. So it would end up being about $7 million. And what we have to understand is that we often don't feel like we have that much money. But remember, this is the proceeds of life insurances, real estate, values of businesses. We also don't know in the coming years what's going to happen to that, depending on, you know, who wins the next election. And that's not good or bad. It's just something that we have to think about. We also use trusts all the time for beneficiaries that have supplemental or special needs. So that would be a child who, for whatever reason, receives some sort of public benefit, medical assistance, SSI, maybe a child who has Down syndrome. I have a nephew who has cystic fibrosis, and he receives what's called MAUD, medical assistance for a disabled worker. So he would need a special needs or supplemental needs trust. So it doesn't matter the diagnosis, it does matter what types of benefits that they would receive. In Pennsylvania, the big one ends up being medical assistance, which often is combined for somebody who's disabled with Medicare. And we want to make sure, for me, it's not just about the money. It's also, we could have somebody who's enrolled in a program, and if they get an inheritance, they get unenrolled in that program because they have too much money. And it's not about just spending down the money and re-enrolling them. They could lose their spot. Unfortunately, in Pennsylvania right now, we have waiting lists for programs and for benefits. And I don't personally see anything that's going to make that any better in the future, unfortunately. Also, the management of our assets upon our death. So who has control, who winds up our business, who makes sure whatever we want to have happen. So in your situation, you know, if you've ever wondered, do I need a trust? For me, the answer would be, well, you know, if you have one of these goals, most likely you could be benefited by a trust. A trust is just a written set of instructions that allows us to, you know, make these objectives and goals that we have. And really important. We do a lot of trust work at our office. I actually wrote the Pennsylvania Trust Guide, which is by Beisel, and it is it's the book that most attorneys across our state use to write trusts. At our office, we write our own trusts. We don't buy a computer software program that just spits it out. So we're able to make it more individualized for people. It does take a bit longer that way, but it's actually really nice for those people who have an opinion and want it done a certain way. and want to, devote some time to thinking about what they want to have happen. The other thing we don't have on here, but I would be remiss not to mention, is charitable needs trusts. So we do a good amount of work with charitable needs. And there can be a lot of reasons to do that with qualified money, IRAs, those types of things. There can be a lot of reasons to do that while you're alive, and get family members involved in picking the charities and becoming part of that. So that legacy planning is also very big in what we do. So to pause for a second, I'm going to kind of switch now to retirement planning and really focusing on qualified money. That was just a glimpse at foundational documents for you. As Kyle indicated, we have a lot of stuff on our website. We have a lot of podcasts. If there's one topic there that you want more in-depth information, you're welcome to look at it. I could talk an hour just about special needs trusts, but don't worry, I won't. I know that you only want to be on here so long. So retirement planning. For many of you, you will have quite a bit of money in an IRA, 401k plan, or some other qualified money. And what qualified money means is that we have put it away for our retirement. We may have deferred taxation on it. And when we pull it out, it's going to be income taxable. And that's actually really important because whether we pull it out in our retirement and have to pay income tax on it, or if we give it to children or other beneficiaries, and when they pull it out, they have to pay income tax on it. So we really want to think about these types of things. I mean, one of the things I just think we've been constantly taught to put our money away in IRAs, and they are a great thing to accumulate wealth, but they're really not great to die with because of the taxation issues. And the most recent legislation on this, the Secure Act, which came into effect December of 2019, made it even worse. So prior to December of 2019, I'll just use my family as an example. If I had $1 million in an IRA and I passed away, I could give that to my children and they could take it out across their life expectancy. So, Courtney, who's 24, Steffi, who's 18, DJ, who's 17, they could take that out over their life expectancy. What the Secure Act did is it came in and it said, no, they need to take it out in 10 years. So what happens is they end up paying more tax because you would understand if I took out $10,000 a year for 50 years, I'm not going to pay very much income tax on that. But if I have to take out, $100,000 over 10 years, that's going to put me in a higher tax bracket. So it's interesting to me, this came in under President Trump, obviously, and it's interesting to me that it's a huge tax on the transfer of wealth in this country, and it affects many people. For me, many of my clients had actually decided not to give their IRAs to their kids, but to give them to their grandkids. So that the grandkids, you could go over the grandkids' life expectancy, but that's not going to work anymore. And so we had to redo some of those plans. So this is, there's great changes in this law when we think about retirement planning. Even before those changes, it's still something we should look at closer. If you already have your estate plan done and the attorney that did it for you hasn't contacted you, I would suggest that you contact them and ask them, given the changes with the Secure Act, is your plan still okay? Is this still the best thing to do? So I know I've had a lot of conversations with my clients after the Secure Act happened. We did seminars like this and invited our clients and kind of explained to them what was changed and then offered to review their files. So that's definitely something. Unfortunately, estate planning, people come to my office and they get it done They hope to never have to talk to me again. But that's just not the reality of estate planning. We have to react to changes both in the law and changes in your life. And so when you work with an attorney, you should really see that as a partnership. They should work with your financial advisor, your accountant, and they should keep you updated because things are going to change. And really, it doesn't matter who's president. The changes are different, but things are always changing. So, biggest thing here. So on any of these types of things, whether it's an IRA, a 401k, or even life insurances, we want to make sure that we know who you have designated as your beneficiaries. You should never have your estate as your beneficiary. That's going to cause the most income taxation. And I have to be honest with you. If you've not looked at your own beneficiaries of your IRAs, 401ks, anything that has that, you should call all the companies or get online if you have an online account and ask them who they have written down as your beneficiary. And the reason is because so many of these companies have been bought and sold, and we assume that the information went with the new company. So when, Voya becomes a new company, we assume all that information goes along. But that's assuming that data entry is infallible, and we know that's not true. So we've had many situations where somebody updated their beneficiary designation, and later on, the company didn't have record of that. I just had a situation where a very good friend of mine, who is a retired financial advisor, re-looked at her own plans and found her ex-husband on it. And her ex-husband had not been on it. She had changed that. So you do want to, make sure. Unfortunately, that is something that has happened. And I can give you many examples at our office where those beneficiary designations were not correct. So first of all, we have to make sure they are who we want them to be. And we should review this on a really regular basis because life happens to all of us. People pass away, people get divorced, our beneficiaries could get sick or become disabled. So we want to think about that. For every thing that you should have a primary beneficiary, a contingent, and what we call a tertiary. So tertiary just means the third beneficiary. Not every company will allow that, but one of the things that we do for all of our clients is we set this up. So if you're married, your spouse might be your primary beneficiary. Your children could be contingent and grandchildren would be tertiary. Or maybe you say, no, I don't want it to go to my grandchildren. I want it to go to my daughter-in-law or my son-in-law. That's up to you. For anybody that's using a trust, really important distinction in the law, particularly with the Secure Act, we don't want to make the revocable living trust your beneficiary. We want to make the sub-trust under it. So again, I'll use myself as an example. I have 3 kids. So in the past, I would have just made my trust the beneficiary, and it would have flowed through the trust to my 3 kids. But when the Secure Act came in, they said, oh no, can't do that. It actually has to pay to the sub-trust underneath your trust. So this is a technical little thing, but really important as far as making sure we don't pay any extra income tax. I can't underscore how important this is, and I chose this topic tonight because I find that very little people pay attention to this, not financial advisors or other attorneys. And if, for instance, I'll just give you, a for instance, and I see this in my practice. You have $1 million IRA and it pays to your estate. That $1 million is going to be taxable in 1 year. Your beneficiaries are going to get about $600,000 of that. That's how important this is. If it pays to, in my situation, if it pays to my 3 kids, they at least can take it out over 10 years, just adding $33,000 of taxation to their individual taxes, and maybe not even having any real effect at all. So I've actually seen that in my career. I did an estate once where there was $3 million of assets, and the beneficiaries, until we paid the federal estate tax, the exclusion was lower then. I talked about it as $11 million now. When I started my career, it was $600,000. Until they paid the income taxes and the federal estate taxes, the beneficiaries only got 1 million of the 3 million. So it's important. Income taxes are really important in estate planning. So our inheritance taxes and federal estate taxes, but I find it's the income taxes that are avoided. And I find that you guys as a group have really, I don't know, when you guys are in medical school, do they teach you to put stuff away in these IRAs? I find as a group, you guys have accumulated a lot of wealth in IRAs and 401ks, and people aren't talking to you enough individually about what does that mean in your particular estate. So it's a really important conversation. I already talked about this. You don't want to name your estate as your beneficiary or contingent beneficiary of your retirement plan at all. Sometimes we do want to use charities. I'll talk a little bit about charities before I get into layering the designations. One of the things that's happened with the Secure Act is really wanting to maybe use more charitable beneficiaries, if that's in line with your goals. Because what can happen is the money that now would go to the government in taxes ends up going to the charities. Your children end up getting the same amount of money. It's just who gets it. If you, and I'm sorry for this aside, but I just realized, how important. What I see attorneys doing many times is they say, well, I want $50,000 to go to the YWCA, or I want 10% of my estate. You shouldn't do that. What you should do is you should leave to those charities some of this money that I'm talking about, this IRA money, 401k money, because those charities don't pay tax. So if I leave $100 to my kids and they pay tax on it, they end up with, $60, $70. If I give $100 to the Lycoming County Medical Society, I assume it's a charity, nonprofit. If I give $100, they get to keep the whole $100. So important. So never just leave a specific bequest in a will or give a percentage of your estate. Now, please know, I work with people who say, it's important to them that 10% of their estate goes to charity. Well, we figure out what 10% of their estate is, and we allocate this qualified money that's income taxable to fulfill that 10%. Otherwise, it kind of is like 10% off the top. Also, layering your beneficiaries is really important. I don't know. Many of my clients seem to think who's going to die in what order. And, I have many people that I work with that they just make their spouse the beneficiary and nothing behind that. No contingency. And we don't know who's going to die first. And what I can tell you is that if somebody's spouse dies, they're not really excited to come to me and talk about their contingent beneficiaries. That's why I think it should be all set up at the same time to say, it goes to my spouse. If my spouse isn't here, it goes to my sub-trust for the benefit of my kids. If my kids aren't here, it goes to my grandchildren, or whatever, you want to do. Here's where you can name your children outright. Outright means they just receive it. You also can name them under children's share under irrevocable living trust. And that's what I was talking about with my kids, so that if I passed away, my children would receive it under that trust, partly because some of them are younger, partly because if it's in a trust and they get married and the marriage doesn't work out, whatever's in that trust is not subject to equitable distribution. So, I consider myself extremely lucky. I have raised 3 children, kind of almost. My oldest daughter went to Northeastern and she lives in Boston and she's an accountant. She's wonderful. I would trust her with money. In fact, she would probably bring in a laminated Excel spreadsheet with her whole entire budget, better than I would ever do. But you know, she's not married yet. We don't know what that's going to look like. We don't know if that's going to stick. And I certainly wouldn't want to pass away at a time when she was in a marriage that wasn't going to work. And my money ended up being split in that marriage. And so that's what the revocable living trust does. Or I'll use my son who's 17, who actually can hear what I'm saying right now. Just got home from football. You don't want to give money to a 17-year-old. Partly because they could be going to college, partly because, you know, it's just too much responsibility for a child that young. And so we often use a revocable living trust to provide protection. Again, from what I already talked about, the 4 Ds, death, divorce, disability. Sometimes my clients say to me, but I have good kids. And I always say to them, so do I, you know, but life happens to us. It isn't about having good kids or bad kids. It's about having children or beneficiaries that life can happen to. And we don't know who that's going to be. And so if we've worked so hard to accumulate this wealth and we decide to pass it down, we should do it in a manner that's most protected and in a manner that they pay the least amount of income, federal estate, and Pennsylvania inheritance taxes. So really important work to be done. This just goes over those 4 Ds that we worry about. We also talk about this. This is one of the reasons, you know, many attorneys will say, oh, just give your house to your kid for $1. I say no way, because all that does is subject your home to their lives. You know, again, the intentional and the unintentional of it. So important to think about that. Now, I'm going to now flip into a little bit of a more complicated issue, but again, I picked this because it could affect some of you. For some of you, I'm going to guess that you already have a revocable living trust. I'm going to guess that for some of you, you already have a trust that your children are a benefit of. And the next question we have to decide is it a conduit trust or is it an accumulation trust? A conduit trust, you know, my husband does excavating for a living, and I always remember him talking about conduit piping. You know, it travels through it. So if, you know, piping, it travels through it. A conduit is something, you know, sound can travel through. So that means that the money comes in and can travel right through that trust down. Accumulation means that the trust is going to accumulate it. So for some reason, I don't want it to travel through. I want it to stay there. So I talked to you about kind of both types of those. You know, if my son was 17, I might be using an accumulation trust because I want it to accumulate for him. But my daughter who's 24, I could use a conduit trust, which means it goes in, hey, I really trust her. If she wants to take it out, she can. And that's a conduit. So again, I'm going to make a guess that many of you, if you have revocable living trust, it's either a conduit or an accumulation. So if I have an IRA, 401k plan, you know, I have the required minimum distribution, and that will go into the conduit trust. And if it's a conduit, it's going to go out every year to my beneficiary. It looks at the life expectancy of the primary beneficiary, although, you know, with the Secure Act, that's only 10 years if it's a child. These types of trusts must be rewritten because of the Secure Act. There's a problem with the taxation with the Secure Act. And it doesn't mean, please know, if we think about, if you're thinking, wow, I already invested in that car, that trust, I already paid a good amount of money to get this all together. Think about this as, you know, getting the oil fixed or, you know, the oil changed or like the brakes fixed. This is a small thing, but it's really powerful in the amount of income tax your children are going to pay. And so, you know, one of the things that we do at our office is we look at other people's trusts. we don't say to people, oh, you need to redo all of this. A lot of times a revocable living trust is pretty standard and it works, and we don't have to unfund and refund everything. We can just kind of restate it to, maybe spruce it up a little bit. So I know when I start talking about law changes, everybody's like, oh, I have to redo this. That sometimes happens, but the majority of the time, it's a little bit more of just kind of sprucing it up a bit or maintaining it, but really important. Accumulation trusts, what happens is the required minimum distributions, that $10,000 that is paid out over 10 years, it actually just stays in the trust. And this gives us maximum creditor protection. But the problem with it is it's going to cost us large income tax bills, because trusts pay income tax at higher rates than individuals do quickly. So after a trust makes $12,000, it's going to pay income tax at the highest rate. So if you have an accumulation trust and we're not able to push those RMDs out, we have to think about, does that make sense now after the Secure Act? So we have to just think that through. And please know, we would never make a decision solely based on taxes. We have to know what the tax consequence is. For some of you, you will say, I don't care. That's still what I want. And that's an okay answer. For some of you, if you really want an accumulation trust, I would suggest that you change your trust to a charitable remainder trust, because what happens then is the money that would have went to the government in income taxes is going to go to a charity. I've done many of them over the years, and it's amazing how it kind of works out really well. So it's one of the things, conversations I had with a lot of my clients was, do you want a charitable trust? Do you want to change this? What do you want to do in that situation? It does take in consideration the life expectancy of all beneficiaries. So that's where I have to think about, well, do you have a child who has special needs? Are you giving some money to your sister, some money to a child, some money to, sometimes I work with individuals where maybe the second spouse is close in age with the oldest child. So we have to think about those things. There's all kinds of, it's beyond the scope of tonight, but just know there's all kinds of little trip ups in the tax law about if a beneficiary isn't 10 years younger than you, they get one type of treatment. And if they are more than 10 years younger than you, they get a different type of treatment. So sometimes when I'm working with people who are giving money to siblings, that really comes up. Because many times our siblings aren't 10 years younger than us, and they can use a different set of rules. So, ooh, sorry. So it is really important to take time to review how the retirement money is invested. Traditional IRAs, 401ks are taxed upon distribution. Now, some of you may already have Roth IRAs, and Roth IRAs means that you took your traditional IRAs and you transferred them into a Roth, and you already paid some of the income tax on them, so that when they continue to accumulate, you don't have to pay the income tax again. I think some of the best planning is coupling the two of them together. But before you do that, we need to work with an accountant who's going to really be able to advise about the income tax consequences of that. And that's an individual decision. It's not something I think everybody should do, but it is a consideration, I think. And one of the reasons that particularly any of you that are younger here, you really want to think about doing that. And the reason is because even though it doesn't feel like it, historically, we are at all-time lows at income taxation rates. So I don't know if you know this, but there was a time after World War II where income tax rates were like 97%. So if I made $100, 97 of it went to the government and $3 came back to me. Up until the 70s and 80s, some of the highest rates were in the 70%, 74%. Now, this is your personal choice. I can't tell you what's going to come with income tax rates. But I can tell you a conversation that I have with my clients is just a look at even what's happened this year and the amount of money that our government has given out and the amount of debt that we are in as a country. We are in more debt per capita than we were after World War II. So at some point in time, and I don't know when that's going to be, income tax rates are likely to increase. So if I was younger, it might make sense to convert to a Roth IRA today, and allow that money to grow tax-free so that when I took it out, if there were higher income tax rates, I wouldn't have to pay that. Now, I guess I should define for you what's younger for me, because remember, most of my clients are older. So if you're 60, you're younger for me. So, please know, and please know, everybody should think about it, but your time horizon, the longer your time horizon is, probably the more likely that this is something you should think about. Also, I can tell you how I view the world, but whether or not that matches with how you view it, that's up to you. But I would say to you that many of my clients, we have to think about, are we right now paying the lowest income tax rates that we will see through the rest of our lifetime? And it's possible. It's possible. Okay. So, income taxes and our beneficiaries. I will tell you, this is a little bit more kind of detailed. I also don't, with my clients, necessarily say all 3 kids, or how many kids you have, or how many beneficiaries should all get, like in my situation, a third of everything. Some of you will have beneficiaries that are in higher tax brackets than others. If, for instance, I have a child who has special needs who doesn't work, I might want to give them more of the qualified money. And let's say I have a child who is affluent themselves, maybe they themselves are in a higher tax bracket, I might want to give them the money that's not as taxable. So we do want to take time to think about, can we think about this at a deeper level? What is the best option for people? Now, please know at our office, whatever time you want to spend, we're willing to spend with people. For some people, they just want simple, and that's fine. But you definitely are a group of people who, if you invest a little bit of time in doing this, can really affect and leverage the amount of money that your beneficiaries end up with going forward. So I know the topics just keep getting more exciting. What happens if we need long-term care? Well, long-term care is not covered under Medicare. So Medicare essentially was created at a time that long-term care didn't really exist. In the 1950s, people got sick and they either got better or they passed away or they were cared for at home. Today, people can access the long-term care system for quite a while. And your Medicare and most of your health insurances are not going to pay for that. They're going to pay for acute care. When the Affordable Care Act came out, there was an attempt to think about long-term care for this country, and it was quickly abandoned. So most long-term care is private pay. You pay for it as you go. For some people, if I was working with a husband and wife who maybe have a house and $200,000, I might try to put some of their money into a trust because I don't want husband to get sick and the wife to spend all that money on his care and then be left financially destitute herself. And that happens in this country, unfortunately. In your situation, if you have more assets than that, we want to take a deeper look at this. We want to say, should we use trust to protect and access the public benefits? Do we want to think about creative financial products that would help leverage and cover the cost? And just so you know, from my perspective, one of the most important laws is the Pension Protection Act. Excuse me. And what that law said was that if I used money, maybe in an annuity that had a gain within it, so a gain is going to make it when I pull it out, I'm going to have to pay income tax on the money that it gained. If I use that money and I buy a special Pension Protection Act annuity, when I pull the money out for long-term care, I don't pay any tax on it. So what it does is it really leverages your money. This is, a classic case of the government wanting people to take care of this themselves. It's different than traditional long-term care insurance. It's very hard to qualify for traditional long-term care insurance. That's the type of insurance that, just like our homeowners or our car insurance, we pay for it. If we never use it, we lose it. And the problem with traditional long-term care insurance is that the rates, the premiums have skyrocketed over the years. I actually did a lot of work at this. I actually went to to Indianapolis. I've also went to St. Louis and did some training about these different products. And essentially, the long-term care industry, insurance industry really made a bad call. They thought that people would buy long-term care insurance and they would let it lapse. They would just stop paying the premium because that's what people do with life insurance. Well, that's kind of dumb. Across my lifespan, when my kids are out of the house, my mortgage is paid off, I don't need my life insurance, and so many people let it lapse. When I buy long-term care insurance and I start to get some aches and pains, a little bit sicker, I'm going to keep it because I'm going to need it. So what we have is large costs. I personally like long-term care insurance as a rider to life insurance. See, in the state of Pennsylvania, if I buy life insurance, they can never increase my premium. It's contractually fixed. If I never use long-term care, it pays out to my beneficiaries as a death benefit. And that's really beneficial in Pennsylvania because I don't pay any income, inheritance, or federal estate tax on it. For some of you, you may not be able to get long-term care insurance with an insurance base because of medical issues that you have, in which case you can get it with what's called an annuity chassis. It's annuity base. Still, what you are able to do is to leverage your money to have a death benefit to pay for long-term care. If you never use it, it pays out to your beneficiaries. And just from a logistical standpoint, I think those prospects make more sense. So that's something that you should spend time looking into. At our law firm, we're not allowed to sell you those types of products because it's not allowed in our state. So what we do is we work with a company who specializes in it. We also are very willing to work with whoever your financial advisor is, but we found that many financial advisors are really great at letting you know how to grow your money, but they don't have an understanding of these financial products. And so, we invite anybody to be part of the conversation, but we really want to make sure that we get the best option for you. For all of this, it's an investment of your time to come to the table, get yourself organized, figure out what you have, and figure out what you want to do. But that time really pays off to your beneficiaries, both in not getting into fights about what they think is supposed to happen, but also not to be burdened with a mess. At my office, I talk to people about pre-planning your funerals so that it's done, so that, when we're in a crisis situation, we don't have to go do that. So, some takeaways for tonight. It's really important to focus on the whole picture. I really think you should desire to have a group of people, your financial advisor, your attorney, your accountant, who are willing to work together. At our office, we always write down a written plan so we all are on the same page about it. You don't want to create one problem when trying to avoid another. And that's what we find many times when people don't have the right beneficiaries. They're, creating a problem. They don't even realize it. And unfortunately, when somebody dies, it's really hard to fix these things. Trust me, I have tried, sometimes successful, but sometimes not. You do want to consult an elder law attorney. who is knowledgeable about all types of taxes, income taxes, estate taxes, inheritance taxes. And if the attorney that you use and you feel comfortable with doesn't know that, you always can consult a specialist. So in our office, we often work with other local attorneys who maybe that local attorney is great at the foundational estate planning documents that we talked about, but they don't have the specialized knowledge in income taxation. And so we're always willing to help out in whatever way. At our office, we do have a team of attorneys, certified Medicaid planners, support staff. We do pride ourselves on individualized planning. We don't tell every client to do the same thing. Sometimes it takes a while to work through these things, but I think, you know, my goal is for people to be comfortable, to have quality legal documents, and to really have peace of mind that this is done. I know a lot of times people are now saying, oh, you know, I'll wait until COVID's over. We don't know when that's going to be for sure. But we do a lot of our appointments by Zoom, by technology. And actually, for some of you, I know physicians always have very tight schedules and you have odd hours. So actually doing it by Zoom or by phone could actually work out better for you because you don't have the travel time to our office. But our goal is definitely to provide the same service as face-to-face meetings. And again, you know, my job was to help you tonight. I would say the same thing if you decide to go back to your attorney who does this. Don't wait until it's over, because who knows what's going to happen. We want to make sure. At our office, we do follow up with a phone or a Zoom. We review all the documents ahead of time, ensure everything's correct and that your goals are made, so that when you come in for the signing appointment, you're only in our office a very short period of time. We do follow all of the recommended guidelines during the sanitation, requiring the mask and the social distancing. The only time we don't wear a mask, we do have clients who are very hard of hearing and they're so used to reading lips. We'll then, just wear a shield. So we're here for you. Our office has remained open remotely. Our staff is working hard. And on the screen, you'll see our website, paeldercouncil.com. On that website, you or any of your patients can get a free healthcare power of attorney. That's one of the things that we did during COVID because it was really difficult when we were shut down by the governor, because we do have clients in crisis. And any given day, I could be walking into the hospice unit. I could be working with somebody who's dying of cancer. And so we put a free healthcare power of attorney up there, and it's still up there. Anybody can take advantage of it. There's also a lot of more specific information if there's a topic. But you also can email us at info@PAElderCouncil. Kyle mans that email, if you will, and we'll make sure your question, I'm happy to answer any questions that you have. You also can stay connected with us on Facebook, our YouTube channel. We actually have a podcast called The Second Half of Life. And that podcast is available both on our website, but on Apple, Spotify. And so, we really think the more we can get information out to people, the better. This just shows you a little bit more about the Second Half of Life podcast, when there are multiple ways to access it. Gosh, Kyle, I didn't even know about the iHeartRadio and TuneIn plus Alexa. So some great things.
Yep, you can just pull it right up on your phone.
Also, for all the books that we talked about, you are welcome to get a free copy of those books. We mail them out all the time. If you want any more information in that form, you can email at info@PAElderCouncil or khetner@PAElderCouncil. And we'll send you out a copy of a book.